G'day everyone, Mark here. Just giving you the next exciting instalment in regards to Joden Finance and Sanche Preslip, the geriatric guy that managed to get tens if not hundreds of thousands of money paid in legal aid by the public purse while he's still driving around in Mercedes-Benz. So something wrong there. Apparently he can't work, but he can certainly put a ceiling up in his garage, so that's interesting. But anyway, moving on. This is the judgment of Justice Sarah Katz from the High Court. Anyway, moving on now. This you've seen the video if you haven't already. This is the decision. She said she was going to make a decision on papers in the appropriate way, standard way. I don't know if it's standard for it to take 4 months. I don't know about that, but there are some inconsistencies in this decision that Justice Katz was never aware of, and certainly nothing I ever testified about, but we'll get to that. Alright, so it starts off, Joden Finance seeks judicial review of a district court decision upholding a decision of the Motor Vehicle Disputes Tribunal. So basically, they're seeking a judicial review on Gary Harrison's decision that he made in Auckland District Court back on the 29th of June, where he decided to side with the Motor Vehicle Dealers Tribunal, who never inspected the vehicle, which is their argument was that driving up onto concrete berms, taking chunks out of your tyre, damaging your rims, pulling your mudguards off, damaging brake lenses, all of those sorts of things, that's just general wear and tear. It's not an accident because of someone's, error, omission or neglect, such as not being able to see properly, let alone shouldn't even be driving, and hitting the concrete curb. And then they freely admit doing that, so that would be an accident causing damage. As far as the Oxford Dictionary is concerned, Anna, the damage would be defined as the verb definition, not the noun that you conveniently left out on the 29th of June. So, but then that might have had something to do with a little chit-chat that I believe Anna and Judge Harrison had just before the proceedings were actually commenced. So, because we saw her wander off up to the same area where the judges go. So, and then all of a sudden, she just happens to have the Oxford Dictionary's definition of damage. It's weird. Anyway, the underlying dispute is between Joden and the second respondent, Sanche Preslip. We'll just call him the SOA. Okay? You can figure out what that means. The underlying dispute, is that and between SOA. It relates to a Mercedes-Benz S350 motor vehicle that Mr. Preslip purchased from Joden. Yep, he purchased it, and then he tried to bring it back and swap it for another vehicle that came on the lot shortly afterwards, and John wasn't wearing that. He'd already sold that vehicle. Why would he take it back just to get him into another one? In that short time, he had already caused damage. And then, strangely enough, as soon as John said, no, I'm not swapping it, it came back within the next week, and someone had gone and put water in the cooling system. You put antifreeze in the cooling system, or whatever's recommended. You don't just put water. But anyway, moving on. Isn't it strange how those things happen? The tribunal found that the vehicle failed to comply with the guarantee of acceptable quality in Section 6.1 of the Consumer Guarantees Act, the Act. In particular, the vehicle had faults with its cooling, airbag, anti-locking brake systems, and electronically stability control. They're just warning lights, and John had all of those fixed. The cooling system, as I said, someone had gone ahead and put water in there. I wonder who. And yes, John still has the original old radiator because he replaced the whole radiator. That was back when he got it. Anyway, the tribunal found that Mr. SOA was entitled to reject the vehicle. Really. And yet, even though admitting to have an accident to the motor vehicle dealers, they're still saying that's general wear and tear. Well, fuck, so's the ABS light coming on. That's faults occur all the time. That's just ordinary wear and tear. It's through no fault or error of John's, or the person that's selling the vehicle. Anyway, the tribunal found that the SOA was entitled to reject the vehicle. Judge Gary Michael Harrison in the District Court at Auckland upheld that decision on appeal, even though he's not bound by it, or is he? We don't know. I don't think he did. There is no further right of appeal. Well, that's bullshit, because obviously we can go for a judicial review on your decision, Gary, can't we? Because you're not the highest court in the land. You're just down there in the fucking lowest one. Moving on. Instead, Joden seeks judicial review of the District Court decision on the grounds that A. The judge erred in finding that the right to reject the goods under Section 21C of the Act was not lost if the purchaser caused minor damage to the goods after delivery. It doesn't specify minor, major, small, insignificant, huge amount. It doesn't specify amount of damage. It just says damage. Damage is that what causes a loss in value. For those like Anafuiaba who can't actually work out what damage means, I suggest you use Butterworth's Law Dictionary in the future, honey, especially if you're getting your law definitions and your legal definitions correct, okay? You're supposed to be a legal interpreter. Do you not understand that? The judge erred in finding that the damage caused to the vehicle by Mr. Preslip was minor. The tyre was over $500. The damage to the rim was near $600 or $700. So you're talking over $1,000 worth of damage just to the tyre. That's not counting the bumper getting ripped off, not counting the extra dings and bumps that he's put into the glass lenses at the back of the vehicle, not counting any of that. C. The judge erred in finding that the damage was consistent with ordinary wear and tear. Yes, he did. He even tried to tell John if he could, just buff it up and put some cutting compound and polish up, you would still be able to sell it perhaps even for a bit more. Well, I don't know. The guy certainly committed fraud, because coming up next, guys, I have the video of the recollection of the vehicle from the SLA.
Painted the wheel! Painted the wheel! Look at the tail lamps, Steve. The tail lamps.
Yeah, broken. So did he paint the front wheel?
He's painted the front wheel.
Alright. And D, the judge erred by failing to take into consideration that the damage was caused by Mr. Preslip parking accident, and it is unreasonable to find that damage caused by a parking accident is consistent with ordinary wear and tear. Egg fucking's actually right. It's not ordinary wear and tear to ride up onto a concrete curb because you can't see properly. Alright? Mr. Preslip's purchase of the vehicle and the discovery of faults. 11 days after Mr. Preslip had purchased the car, a leak in the cooling system became apparent. Could have been because he put water in it. Joden repaired the car. Shortly afterwards, the same issue reappeared. Wow, guess he should stop putting water in it. Joden repaired the car for a second time. Immediately after Mr. Preslip had picked it up, the cooling system leaked again. Well, I don't believe that's correct, but that's according to him. The car also had a range of other faults. Specifically, warning lights were on for the airbags, the electronic stability control system, and the anti-locking brake system, all of which was fixed by a simple clearing of the faults. They didn't exist. They were previous faults that had been fixed but not cleared. And all you got to do is hook up an OBD2 and clear the fault. 6. Mr. Preslip invoked his right under the Act to reject the vehicle. Joden refused to accept that rejection. The Consumer Guarantees Act 7. The purpose of the Act is to contribute to a trading environment in which the interests of the consumers are protected. Businesses compete effectively and consumers and business participate competently. To this end, the Act relevantly provides the consumers have A. certain guarantees when acquiring goods or services from a supplier, including that goods are reasonably safe and fit for purpose and are otherwise of an acceptable quality, and Well, for the first 11 days it seemed to work fine by the sounds of it. And again, faults happen, whether or not they're user caused or not. And again, John honoured the warranty and fixed all these faults. B. Certain rights of redress against suppliers if goods fail to comply with a guarantee. Alright. 8. The Act therefore has a strong consumer protection focus. Section 6 of the Act provides that where goods are supplied to a consumer, there is a guarantee that the goods are of acceptable quality. Section 7 defines acceptable quality as meaning that the relevant goods are fit for all the purposes for which they would be commonly supplied, acceptable in appearance and finish, free from minor defects. Okay, so free from minor defects, but not free from minor damage. So they've all found that there is so-called minor damage, and yet they're okay for John to accept it back and accept there'll be no loss incurred if he tries to resell it. Bunch of bullshit. The SOA perjured himself. It's real simple. The photos he supplied, there was some serious questioning on those, but they didn't want to go into that. Why? Because the guy admitted through his own error that he had a parking accident. Through his neglectful actions, he caused a loss of value on the vehicle. Seems pretty simple to most people, doesn't it? Minor defects, safe and durable, and as a reasonable consumer would regard as acceptable, having regard to the nature of the goods and the condition of the sale. 9. Where goods do not meet the guarantee of acceptable quality, a consumer can require the supplier to fix the problem. Where the supplier fails to fix the problem, or the problem either cannot be fixed or is of a substantial character, the consumer can reject the goods. A failure to comply with the guarantee of acceptable quality will be of a substantial character where, among other things, the goods are unsafe. A consumer who rejects goods can elect either a full refund or replacement of goods if replacements are reasonably available to the supplier. 10. Section 20 sets out the circumstances in which the right to reject goods may be lost. Decision of the Motor Vehicle Tribunal. 11. As Joden did not accept Mr. Preslip's rejection of the vehicle, the case went to the tribunal. The tribunal held that the vehicle was not of acceptable quality and hence Mr. Preslip had the right to reject it. Joden had not succeeded in repairing the vehicle's cooling system or any other of the other issues within a reasonable time, as required by Section 18(2)(b) of the Act. The tribunal also found that the presence of warning lights was a failure of substantial character as they related to the safety of the vehicle. Either of these matters entitled Mr. Preslip to reject the vehicle. 12. The tribunal considered whether Mr. Preslip had lost his right to reject the vehicle pursuant to Section 21(c) of the Act, which provides that the right to rejection may be lost if the goods were damaged after delivery to the consumer for reasons not related to their state or condition at the time of supply. I don't know, not being able to steer your car correctly up onto a concrete berm and ripping your fucking tyre to shreds. I'd consider that nothing whatsoever related to the condition of the supply. And who's saying that that didn't happen on that first 11 days? It's all because he wanted to upgrade it to another vehicle. And John said no. And then the problem started. 13. Mr. Preslip admitted that he had hit the curb while parking the car. There you go. By his own error or omission. Or we'll just say, his ignorance of being able to drive a car correctly. This impact had caused damage to the left rear wheel. Wrong. See, they can't. So perhaps Judge Katz, if it really was Justice Katz that wrote this decision, because I'd like to point out that it ain't frickin' signed, Justice Katz got the wheel wrong. It was the front left wheel. That's the wheel that you're steering into when you're pulling into a car park. The passenger front wheel is the first thing to hit the concrete if you steer wrong, and that's exactly what frickin' happened. Joden alleged that there was also damage to the panelwork in above the damaged wheel, because he'd ripped the bumper off. Mr. Preslip denied this. After reviewing the photographic evidence, the tribunal was not persuaded that there was damage to the panelwork. What, did they not see the bumper hanging out from where it should be? Even if it's just a simple push in to fix it, or an undo of a 10mm nut underneath the wheel arch and then pop it back in again, it doesn't frickin' matter. It's damage. And granted, that panel worked, you know, but then there's replacement of the lenses as well that he also damaged after that as well. 14. In its view, there was no damage to the vehicle that required any repairs other than normal wear and tear. Then why did Arrow Wheels in their affidavit stating that the rim to be repaired, okay, to repair something it must be first damaged or faulty? This was not substantial enough to qualify as damage, really. And who determines that qualification? I think the legal definition of if it incurs a loss, and if that car gets appraised and John can't sell it for the same price that he sold it to the SOA, anyway, within the meaning of the Act, Mr. Preslip had accordingly not lost his right to reject the car. District Court Appeal 14. Joden appealed to the District Court, as is apparent from Joden's notice of appeal. In its written submissions on appeal, Judge Harrison's interlocutory judgment declining leave to Joden to adduce fresh evidence. Yes, see, this is when Gary stood up and leaned over the top of where he sits there and says, "This is my court." You know, what part of no don't you understand, Mr. Murphy? You know, does any of that ring a bell to you, Gary? Because apparently that's what happened. Because you see, I wasn't at any of the previous hearings earlier than the 29th of June. And take note of that, okay? I was never at any of the tribunal hearings. I wasn't at the court hearing when old Gary got up and leaned over and said, "No, what part of that don't you understand?" You know? That doesn't sound very impartial, does it? Joden's appeal was advanced on a narrow basis. 15. Joden was represented at both the tribunal hearing and the District Court appeal by its director, Mr. Murphy. The sole ground of appeal advanced by Mr. Murphy was that the tribunal had erred in its interpretation of Section 21C. Joden's position was that the 21C did not specify that a particular level of damage had to occur in order for a purchaser to lose their right of rejection, let alone 1,000 plus damage. Rather, the section envisages that any damage caused after delivery to the consumer for reasons not related to the state or the conditions of the good at the time of supply would result in the loss of the consumer's right of rejection. As the tribunal had found there was damage to the vehicle, Mr. Murphy argued Section 21C was engaged and the right of rejection was lost. 16. Given its focus on the statutory interpretation issue, Joden did not appeal the tribunal's factual findings. On the contrary, it relied on those findings to establish that the vehicle had been damaged post-delivery to the SOA, and hence on Joden's interpretation of 21C, the right of rejection had been lost. 17. Joden could, of course, have it advanced alternative grounds of appeal. So now they're telling him, oh, well, you should have done this. First, that the tribunal had erred in its interpretation of 21C. Alternatively, that the damage to the vehicle was significantly more substantial than that found by the tribunal, who didn't even physically look at it, and that right of rejection was therefore lost, even on the tribunal's interpretation of 21C. Joden focused solely, however, on the first argument. 18. Nevertheless, Joden applied to admit fresh evidence on appeal. That evidence comprised photographs which Mr. Murphy submitted showed a greater degree of damage to the vehicle than the photographs that had been before the tribunal. That's because Preslip supplied them. And that's because they wouldn't let John inspect the vehicle. Why not? Something to hide, something to cover, something to perjury? You got to wonder. Judge Harrison, who heard the application, acknowledged that on the face of it, the further evidence could be relevant to the right of the purchaser to reject the vehicle, presumably on the basis of the alternative argument in 17 above. The judge recorded, however, that Mr. Murphy says that is not his case. His case is that the tribunal's decision as it stands is wrong by reason of the findings of the tribunal that the damage referred to in the evidence by the tribunal is sufficient to warrant application of Section 21C. That being the case, there is no basis upon which any further evidence should be called at the hearing or appeal. Oh, really? So we're just going to keep our heads in the sand and just ignore all the other facts that we'd like to point out. 19. Joden maintained its singular focus on the statutory interpretation argument at the District Court appeal hearing. In its written submissions, Joden referred to 3 decisions of the tribunal, all decided by Mr. B.R. Carter, in support of its submission that any damage, no matter how minor, would result in the loss of the right to reject a vehicle. Mr. Murphy submitted that those decisions were determinative. 1. If there is a finding on the facts that the purchaser has caused damage to the vehicle, even minor damage, that was caused after delivery for reasons not related to the state of condition at the time of supply, then the right to reject the vehicle is lost by virtue of 21C of the Act. As the tribunal has said, there is no discretion. It has no option but to decline any application to reject the vehicle if 21C applies. Emphasis as per original. Judge Harrison dismissed Joden's appeal. He noted that in 2 other decisions in which Mr. Carter had been the arbitrator, he had not viewed the interpretation of 21C in such absolute terms, and has instead asked whether or not the damage to the vehicle exceeded normal wear and tear. Okay. So now he's saying he doesn't have to listen to the tribunal? See, he can't make up his mind whether he's going to stick by them or not stick by them. And the reason being is because Carter and the tribunal erred in their judgment that it was ordinary wear and tear. And John supplied 3 other cases where Carter had adjudicated, even when they had a home tune guy coming back into the car, nothing to do with the purchases or the delivery or supply of the vehicle and how it performed. It was sitting there parked, another car hit it, she went and got the bumper repaired, like new, tried to return the vehicle, wasn't accepted because there had been a repair done. Damaged after time of supply. Real fucking simple, through no fault of her own. It was home tune that did it. It was all covered by the insurance and fixed. She still tried to return it, and Carter said no. 21C applies. Anyway, Judge Harrison noted that Section 20 was only relevant if the tribunal had already found that the goods supplied breached the guarantee of acceptable quality in the Act, and that those faults were of substantial character. He considered that it would not be in keeping with Parliament's intention to let Section 20 operate in the manner contended by Joden. Instead, His Honour considered that the damage had to impair the value of the vehicle to such an extent that it would be unconscionable to force the supplier to accept it back, which is exactly what he fucking did. Judge Harrison noted that in this case, the tribunal had found that the damage did not exceed fair wear and tear. The SOA had not therefore lost his right to reject the vehicle. Joden's appeal was dismissed because the stupid old geriatric bastard and old Anna Fuiaba had gone and had a little chit-chat before the hearing, and I'm lay a bet, well, let's just say John wasn't part of that discussion. I would have thought that you can't actually, one party cannot just have a word to the judge before the hearing. Perhaps I'm wrong. You tell me in the comments what you think, guys. Did the judge err in his interpretation of 21C? 22. The first grounds of review is that the judge made an error of law. Mr. Beard, counsel for Joden, submitted that the judge erred in his interpretation of 21C of the Act. He contended for the same interpretation that Joden had advanced in the District Court, namely that any damage, however minor, will result in the purchaser's loss of right to reject the vehicle or right to reject the goods. Mr. Beard emphasised that if the right to reject goods under Section 20 is lost, then the other remedies in the Act still apply. A consumer would therefore not be completely without remedy. 23. Joden cited the 3 tribunal decisions that had relied on a district court as supporting a narrow and literal interpretation of Section 20. Joden also cited several Australian authorities on Section 262(1)(c) of the Australian Competition and Consumers Act 2010. I'd just like to point out that it made no fucking difference whatsoever to them bringing up Australian law. He might have well just not bothered. Which is nearly identical to Section 20 of the Act. Those authorities, however, do not assist Joden. A. In LSH Auto Sydney Pty Limited versus Sherman, the key issue related to whether the repair of the damage will void 262(1)(c) and permit the consumer to reject the goods. The tribunal did not express a conclusive view and ordered a rehearing. B. Barton v. Bridgman is on point, but explicitly rejects Joden's position. Anyway, catch up with you soon.